it through to the 4:15 time slot, which will of course be the most riveting of all of the presentations here today. My name is Rachel Sowray. I have the pleasure of teaching constitutional law to our third-year students up at the Portland campus. For those of you who don't know, we get to teach third years up at the Portland campus. We have a brand new building this year. It is a lot of fun. I was lucky to be one of the first people to get into this Portland program quite a few years ago. So I'm having a great time being a part of the program now. With me, I have Professor Paul Diller to my left. He is a professor of law and the Roscoe C. and Deborah H. Distinguished Faculty Scholar at Willamette University College of Law. His professional work focuses on state and local government law and public health law. He's written extensively about state preemption and local authority, as well as structures underlying that dynamic, including partisan gerrymandering. More recently, his scholarship has explored the use of emergency powers by state and local officials since COVID-19. Prior to teaching, he was a trial attorney for the Civil Division of the U.S. Department of Justice in D.C. He litigated constitutional, administrative, and FOIA cases. He has a BA and a BS from the University of Pennsylvania, and he attended Michigan Law. And to his left, we have the Honorable Jack Landau, who served as an Associate Justice on the Oregon Supreme Court from 2011 through 2017. Before his election to the Supreme Court, Justice Landau served as a judge on the Oregon Court of Appeals for 18 years, including 12 years as a presiding judge on one of the court's 3 judge panels. He served in the Oregon Department of Justice, first as attorney in charge of the department's Special Litigation Unit, and later as the Deputy Attorney General. He serves as the Distinguished Jurist in Residence at Willamette University, and he's a pro tem instructor at Oregon Law. He holds a BA and JD from Lewis and Clark, as well as an LLM from the University of Virginia School of Law. And they are here today to talk with us about the Moore v. Harper case, how that's impacting election law, and questions about the future of federalism. And I know this is a case that people have seen in the media. It's been talked about a lot. And it seemed almost like when the opinion came out, it was almost sort of like a burst of excitement about what had occurred, but almost no actual discussion about what the implications may or may not be. It was sort of just open and closed. This is what was decided after much speculation. So I wanted to first ask Justice Landau, who I will have to call him that throughout this no matter what he asks, because the judges of the state have just really trained me well over the past 15 years of litigation, and I will be unable to break from that habit. But I want to ask him, the electorate, the political parties, they have been discussing and debating how elections should be administered, how maps should be drawn, who should be in charge of all that for years, decades, quite some time. So how did we get to the point then where this independent state legislature theory case was heard by the Supreme Court?
Sure. And in terms of what to call me, I'll tell you the same thing that I tell my students, which is if I have my robe on, you're required to respect the office and call me Justice Landau. But as long as I don't have my robe on, excellency works just fine. For my money, this is one of the more interesting cases that came out of the last term. It involved an obscure theory that up until a few years ago was hardly heard of at all, but if the court had adopted it, it would have radically transformed election law and the authority of state legislatures and state courts. As it turns out, the court rejected at least the most robust version of that independent state legislature theory. But what I will talk about as we go forward in the next 45 minutes is that there are remnants of it that are still pretty significant and that we all need to be aware of. Here's how the case arose. In 2019, the United States Supreme Court decided Rucho versus Common Cause, and in Rucho the court said the federal courts lack authority to adjudicate partisan gerrymandering cases. The court said, fear not, we're not leaving this area in a complete void because state courts still remain there to adjudicate partisan gerrymandering cases, depending on what state law provides. The court cited as an example a then recent case involving the Florida Supreme Court concerning partisan gerrymandering. Then in 2021, the North Carolina legislature, following the 2020 decennial census, redrew the boundary lines for congressional districting in North Carolina. And the North Carolina League of Conservation Voters challenged that on the ground that it entailed substantial partisan gerrymandering. They took the case to state court following what the Supreme Court said in Rucho. The North Carolina Supreme Court agreed. The North Carolina Supreme Court said, we, unlike the Supreme Court of the United States, do have authority under the state constitution to adjudicate partisan gerrymandering cases. And the court concluded that, in fact, there was some pretty extraordinary partisan gerrymandering. There was evidence that the map was more favorable to Republicans than 99.999% of all possibilities. What that meant was that if there was a 50-50 split between Republicans and Democrats in North Carolina, of the 14 seats, the Republicans would still get 10, and the Democrats would only get 4. There's a North Carolina legislature, as I recall, he was the Speaker of the House, Timothy Moore, sought review in the United States Supreme Court. The court took review. Interestingly, Moore's theory was not that the North Carolina Supreme Court was wrong as a matter of state law. I mean, that's an interesting issue all on its own, and Moore said, I take it as given that the North Carolina Supreme Court was correct as a matter of state law. His theory was that the very idea that the North Carolina Supreme Court was even second-guessing, even adjudicating this issue, violated Article 1, Section 4 of the federal Constitution, which provides that state legislatures have the authority to regulate the time, place, and manner of elections, subject to regulation by Congress if Congress so desires. There being no congressional legislation as to this, Moore argued, the state Supreme Court has no authority. The legislature, not state courts, not the state generally, the legislature is given authority to create these boundaries, and that's the end of it. Where this theory comes from is the subject of some dispute. As a textual matter, as I just said, the proponents of this theory say you have to look at the text of the Constitution, which confers on state legislatures, not the state courts, not the governor, legislatures the authority. And because of that, as a textual matter, only the legislatures have any say about this. Historically, they try to make a case. Unfortunately, there isn't any contemporaneous history that is contemporaneous with the adoption of the Constitution. But the earliest that they could come up with is in the 1820s, 1830s. There were some examples of people adopting this. Prominently is some debate over the Massachusetts Constitutional Convention and the authority of state courts to regulate the state legislature in election disputes, and such legal luminaries as Joseph Story, Daniel Webster said, no, just the legislatures have this authority, period. No one else can intervene here. And then in the Civil War, there were a handful of cases. There were some cases involving state legislatures that had allowed soldiers in the Civil War to vote by absentee ballot, notwithstanding a state constitutional provision that said you can't do that. And there's an advisory opinion from the New Hampshire Supreme Court, for example, that says that the state legislature has the final say. Anything in the state constitution to the contrary, notwithstanding. Opponents argue that, the text actually cuts both ways, because there are other provisions of the Constitution that when they want to confer sole authority on some institution will say the legislature has the sole authority, and there's no such limiting language in Article 1, Section 4. In addition, opponents of this independent state legislature theory point out the fact that contemporaneously with the adoption of the federal Constitution, there were state constitutions that limited the authority of state legislatures in their regulation of elections. And the framers of our Constitution would have been aware of the existence of those, and if they'd intended to make such regulations in state constitutions unconstitutional, you would have thought they would have said something about that. That's at least the argument. And finally, there is a whole series of cases from the later 19th century up through just a few years ago with the Arizona State Legislature case, in which the United States Supreme Court consistently rejected the theory. The Arizona State Legislature in particular, the court said there was no basis in the text of the Constitution for limiting the authority of state courts to enforce state constitutional limitations on legislative authority to regulate elections. So that kind of tees up the opinion. And Paul, you're going to tell us about the opinion itself, right?
Sure.
Yep, please do.
Jump right in.
And also make sure you tell us mostly what they're arguing about between themselves.
Yes. Should I get
Yes,
this in front of me
please
for
do.
the folks at home? Okay. All right, that's good. Thanks, it's great to be here. The three main issues that come out of this case are, first, for all the federal courts scholars in the room, if there are any, I'm not one, but is the case moot? And actually, that takes up about half of the primary, majority, and dissenting opinions, and really is quite a disagreement. I won't get into that in a lot of detail. We kind of agreed as a panel to spare you most of that, but we could get back to it later during Q&A if we have time. But the majority hangs its hat on the fact that the North Carolina Supreme Court, while it overruled its reasoning and its holding under the state constitution, that the clauses of the state constitution prohibit political gerrymandering, or at least political gerrymandering of the kind they found in this instance, the judgment of the original decision that prohibited the use of the first map, that still stood. And so the majority says, well, as long as that judgment still stands, it doesn't matter if the North Carolina Supreme Court subsequently said, well, we're out of this business. Justice Thomas vociferously disagrees with that. I'll leave it to the federal courts scholars to decide who really got the best of it, but he has a pretty thorough opinion, Justice Thomas, on that. The second issue is what His Excellency Jack explained in a lot of detail, is whether the Elections Clause, Article 1, Section 4, Clause 1, that says state legislatures shall prescribe the times, places, and manners of federal elections, whether that clause insulates state legislatures from review by state courts. And that's the key question that the majority answered emphatically no. And in that sense, it reaffirmed the holding of the Arizona Legislature versus Arizona Redistricting Commission case from 2015. What's interesting about that to me is that decision was 5-4 with Chief Justice Roberts in dissent. Here he writes the majority opinion, so he's clearly switched sides on that or decided not to disturb that precedent. And so that's an important switch just for those who are counting votes in favor or against this theory. But then answering that second question in the negative, that state legislatures are not insulated from review by state courts, then leaves open this third question that the majority doesn't really want to fully resolve and just kind of throws out some ideas about. And that is, well, what role should the federal courts play in reviewing the work of state courts when they apply the state constitution to what the state legislature did regarding districting or election law? And there the court brings up Bush v. Gore, where you may remember that the majority in that case rested its opinion on the Equal Protection Clause. They found that the counting of the votes by county was unequal. But there was a three-justice concurrence there by Chief Justice Rehnquist, Justice Scalia, and Justice Thomas, who would have gone further. They would have said that the Florida Supreme Court was wrong to get involved at all because it's for the legislature to make these decisions, and the Florida Supreme Court was being too aggressive. in kind of reviewing what the legislature had decided regarding how Florida would run its presidential elections. And so the court doesn't really give us a clear answer there, but they lay out some dicta, I guess, like saying that state courts may not transgress the ordinary bounds of judicial review such that they arrogate legislative power to themselves. How helpful will that be? I'm not sure. Justice Kavanaugh, who concurs, would go a little further. He says something to the effect of, we as federal courts, when we review what state courts have done, we need to examine state law as it existed at the time at which the judges decided this question. That might raise a concern for some, particularly state judges, that you have the federal courts looking over your shoulder and freezing state law in time and saying to the state courts they can't kind of let that law evolve and move it in a different direction. Did I answer all the questions? For now.
For now, you did.
Okay,
yes.
good.
Were there any discussions or opinions that came out in this that sort of gave you pause or concern about anything in the future in particular, or do you want to save that until we get to the more specifics later?
Well, I could just put my property professor hat on, so I don't teach federal courts, but I have taught property for 18 years. That's the first thing I thought of when I read this opinion over the summer was in the takings area, the federal courts have increasingly, since the 1970s or so, gotten more aggressive in reviewing what state courts are doing when they define common law, for instance, or even define property rights under state statutes. If you look at cases, I mean, here in Oregon, of course, the famous case is Thornton versus Hay regarding the doctrine of custom and how far title extends on the beachfront. And nobody, I think, in 1969 thought the U.S. Supreme Court would overrule that decision as a judicial taking, with the idea being that the Oregon Supreme Court's definition of the common law rights and how far they extend, and if they changed that by invoking the doctrine of custom, that somehow constituted a taking. But in 2010, the U.S. Supreme Court, in the case Stop the Beach Renourishment, had 4 votes in favor of the concept of a judicial taking, that it is possible that if a state court redefines the common law in a way that goes too far, that a federal court can step in and call that a taking. So the court did have one paragraph in the majority opinion where they said, see, we do this all the time, like in property. They see it as a good thing, that they're already kind of in that business. But that's, I think, an area of concern, for the future. And to his credit, Justice Thomas points this out. He says, I mean, what are we going to do? Get in the business of kind of reviewing everything state courts do? Even if he might have gone the other way on the threshold question, he is concerned about the court kind of jumping into that fray.
And Justice Landau, so this has very much been publicized as an elections law case, right? And so, but I'm sure that based on your experience, especially as a judge, there are lots of areas that were also flagged for you that this could impact. What else were you looking at specifically?
Absolutely, man. This is just to kind of piggyback on some of the stuff that Paul said. As I said at the outset, the more robust version of the independent state legislature theory, the court categorically rejected. But it said, nevertheless, that does not mean that state courts have carte blanche, that there are no limits to state court interpretations of state law. I kind of scratch my heads and say, well, that's really interesting, because Paul and I have both taught state constitutional law for years, and one of the most important principles in the first couple of weeks of state con law is Michigan versus Long and the independent adequate state grounds doctrine. The Supreme Court of the United States says that it lacks subject matter jurisdiction even to review state court decisions as to matters of state law. But here, it seems like the court is carving out a bit of an exception. Where did that exception come from? I have no idea. This is kind of a theme today. We've just heard about the major questions doctrine from an earlier panel. Where did that come from? I don't know about that either. The court did cite 2 predicates. It said, well, we do this all the time in takings cases, as Paul said, and it said we also do this in impairment of contracts cases. And for me, I look at that and I say, this is unremarkable supremacy clause issues. I mean, to the extent that the state court interprets the state law means what it means. Now, if that law runs afoul of something in federal law, the federal Constitution, then the supremacy clause says that federal law trumps. That's fine. Here, what we're doing is something different. The court says the manner in which the state court decides this election contest cannot exceed the ordinary bounds of judicial review. I don't know what that means. And the Supreme Court said, we're not going to tell you. And that, to Thomas's credit, Paul said, Thomas says, what in the world are you doing? He said, I worry that today's opinion portends serious trouble for the judiciary. I think he's understating the case. Think about it for a second. State courts interpret statutes. And in their interpretation of statutes, state courts adopt methods or approaches to the interpretation. They have rules of interpretation of state statutes. That's state law, the manner in which courts go about deciding what state statutes mean. So if the Supreme Court is passing judgment on the extent to which the state court interpreting that state statute has exceeded the ordinary bounds of judicial review, what law is the Supreme Court applying? Is the Supreme Court determining that the state court violated its own law? Or is the Supreme Court saying, there are some essentially irreducible minimum principles of judicial review as a matter of federal constitutional law that constrain the extent to which state courts can interpret state law? To give you another quick example, I mean, the federal courts, at least up until recently, routinely applied Chevron deference to agency interpretations of federal law. Some states do, some states don't. When the Supreme Court evaluates under Moore versus Harper the state court decision, which law applies? What happens if a state election law is 100 years old? There's a long series of Oregon Supreme Court cases that date back 100 years. And the most recent case is completely controlled as a matter of stare decisis by that long-standing state law. What's the U.S. Supreme Court's function? Is it to go back 100 years ago and then evaluate the 100-year-old precedent and determine whether or not that exceeded the bounds of ordinary judicial review, or does it just review the extent to which the state court complied with ordinary doctrines of stare decisis? I mean, this is really troublesome, and there's some irony here as well that I have to point out. In Rucho, the court said we lack subject matter jurisdiction to pass judgment on partisan gerrymandering cases. Well, what happens if you have a state court decision interpreting state law concerning partisan gerrymandering? And then somebody argues that the state court decision exceeded the ordinary bounds of judicial review. The United States Supreme Court then finds itself in the position of passing judgment on the state court decision with respect to partisan gerrymandering, a subject that the Supreme Court has said it lacks authority to adjudicate. At the very least, it's awkward. And again, somewhat ironic given that the underpinning of Rucho is the court's call for judicial restraint. And here, if there's another theme to today's panels, is people have been talking repeatedly about the extent to which the court is asserting itself. It is arrogating to itself increased judicial power, and this is certainly an example of that.
I don't want to put you too much on the spot, so feel free to do more, but is there maybe a case or two from your time on the bench or maybe as a litigator that you think about as how it could have been impacted by this in a significant way, or maybe just an intellectually fun way to think about it in a different, in a different time?
Well, Paul mentioned a case that's near and dear to my heart, and that's the beach access cases, because in Thornton versus Hay in the 60s, the Supreme Court said that the public in Oregon has a right of access to the dry sand area of Oregon beaches from California to the mouth of the Columbia. Then in a case called McDonald versus Halverson, a case that I just coincidentally happened to litigate on behalf of McDonald, the court said, no, that only applies to a very specific kind of beach, and it doesn't apply to the entire Oregon coast. And then when I was at the AG's office, I litigated a case called Stevens versus Cannon Beach. And that was another case about the extent of the public's access to the beaches. And in that case, the Oregon Supreme Court reverted back to Thornton versus Hay and said the public has this untrammeled right from California to the Columbia, this right of access to the dry sand area of the beach. And Stevens petitioned the Supreme Court to take the case, and the court denied the petition, but there were two dissenters, Scalia being one of them. And Scalia says, wait a minute, this Oregon court has been changing the law of property kind of willy-nilly. And at some point, that's a violation of federal law. Now, you only got 2 votes for that. We were very happy about that. But as Paul points out, there may now be 4 votes for something similar to that principle. And under Moore versus Harper, I mean, who knows if this is, Moore versus Harper is tethered to Article 1, Section 4, and it's about judicial arrogation of the legislature's authority. But there's a broader underpinning there that the Supreme Court seems to be playing with that I'd be really concerned about.
So, since we keep mentioning that this, somewhat has elections, inferences, and other areas, before we completely forget to sort of close the loop on that, I just wanted to ask Professor Diller, so what implications does Harper v. Moore actually have on election law moving forward? And then I promise we'll get back to more property stuff, because I know you're excited about it.
Thanks. Well, I think actually the opinion bodes quite well for independent redistricting commissions that are in state constitutions, because it is a ringing affirmation of the Arizona State Legislature case, which was only a 5-4 decision. This is 6-3. And the majority is really resting a lot on the idea of rules being put into the state constitution. It cites cases involving the initiative, for instance, that the voters can do something through the initiative, and that doesn't necessarily take away the legislature's power under the elections clause. So I think whatever it is reformers might want to do in the realm of election law, they'd be well advised to put as much of it into the Constitution as possible, because then we wouldn't have to get into the judicial interpretation part of it. Now, of course, that might raise other questions like single subject rule and all that, which I don't think we're going to get into here. But I mean, we could. But but if you want to do what Arizona did, and I know there are people in Oregon who want to do this, and put some kind of redistricting commission into the state constitution, which is something that's kind of doable in states with the voter initiative, then the court 6-3 is saying that's fine, and we won't say that that takes away the legislature's power to draw the districts. I would wonder a little more about just kind of more freewheeling interpretation of vaguer clauses, like the clause that the North Carolina Supreme Court interpreted here, which said all elections shall be free in their state constitution. And then they also, in the first opinion that was overruled, relied upon the equal protection, free speech, and free assembly clauses. That's where I think the federal judiciary might be more looking over the shoulder of state courts and saying, oh, you really moved the doctrine here, and that's beyond the ordinary bounds of judicial review. Again, thinking of it in property terms, I think what the court is kind of looking for is an avulsion. Is there an avulsion in the judicial review where things move really fast one way or the other? So, imagine me wondering about one state in particular, Florida. They just put a ban on political gerrymandering in their state constitution that's policed by judges. They didn't actually give the power to district to an independent commission like Arizona did or California has, or several other courts have. So it seems to me now, reading this opinion again, that maybe the Arizona or California way is a better way to go, because you're less likely to invite any kind of federal judicial scrutiny of what the state courts are doing.
Right. So then we've brought up the takings clause. Can you tell us more about why is this somehow connected? What's the excitement about it? And of course, please feel free to jump in as you two can discuss it.
He's much more excited about the takings.
Yeah, I mean, I think we said a lot about it already, which is just this question of, to what extent is the judiciary going to police what state courts do? And what's different in the takings context is you can have interpretations of the common law as well. And that's an area where we always thought, state courts really had a lot of flexibility. And that's what Erie is all about, is, hey, we the federal courts, we're getting out of this interpretation of the common law business and we're leaving that job to the state courts. And so this just kind of raises a question of just how committed is the Supreme Court to that approach.
You mentioned something that triggered something in my mind. The North Carolina Supreme Court decision, and by the way, what happened in this case was the North Carolina Supreme Court initially ruled that the redistricting was unlawful. Then there was an election, and the sides switched in the North Carolina Supreme Court, and the North Carolina court reconsidered the case and reversed itself. And the question then was, well, what's there for the Supreme Court to decide? And that's what created the mootness issue. And for the life of me, I cannot figure out justiciability doctrine, for the last 5 years or so, just mystifies me. But on the merits, the North Carolina Supreme Court relied on the state constitutional provision, as Paul said, that guarantees free elections. And it was interesting listening to the oral argument. Alito, in particular, was very exercised about that and said that was just an illegitimate exercise of judicial authority to take from that general provision, as Paul pointed out, you have these general provisions. How can that possibly be the source of authority for judicial intervention? And I found myself thinking, I wonder what Alito thinks about Westbury versus Sanders, in which the court first adopted the one-person, one-vote rule based on Article 1, Section 2 of the Constitution that says that elections shall be by the people. That was the textual root for Westbury versus Sanders. That if Justice Alito is right, I wonder how safe something like Westbury versus Sanders is, if that's outside the ordinary bounds of judicial review.
You're nodding.
Yeah, this is getting in the weeds, but I think during his nomination hearing, somebody unearthed a memo Justice Alito wrote questioning one person, one vote. Yeah. I don't know if it got into the distinction between Reynolds versus Sims, which is under the Equal Protection Clause, and Westbury Sanders under Article 2, but in his hearing, he renounced that and said, "Oh, I'm all for one person, one vote." So it's a lot of years later. It's 17 years later.
All right. Well, are there any other weeds that you wanted to get into today? You guys we both at one point mentioned there's some rabbit holes or weeds, but I didn't want to cut you off in case. No. Otherwise, we can open up to questions for the group. I know we have some for sure.
Thank you. It could well be easy to explain the tension that came from Moore in that the wariness of state courts is simply both an effort to continue to arrogate to the federal courts and the U.S. Supreme Court authority and a projection or a self-awareness of the willingness of the U.S. Supreme Court to pretty much do what it wishes, and a fear that state courts could take advantage of that same authority that they don't want to acknowledge but they actually exercise, and they'd have no ability to do anything about it, as with the same political question on initiative and referendum and the ability of state courts to do it. So I think it's pretty straightforward that they're just fearful of what they themselves are aware of, and they want to guard against that.
Well,
They shouldn't have done it. They shouldn't have put that in, but.
Yeah, I mean, if you listen to the oral argument, that's what a lot of it was. At least from three of the members during argument, there was considerable fear about state courts essentially usurping the legislative function in regulating elections, and particularly in the context of COVID election cases, where courts were called upon to make some decisions under extraordinary circumstances. There were some members of the Supreme Court that were very, very exercised about that, and that's where some of this comes from.
And just to add to that, one thing that isn't mentioned at all in the opinion, but since Jack mentioned COVID, and it comes to mind, is the executive's role. In a lot of states, it wasn't the legislatures necessarily who responded to COVID and changed some of the rules for voting and made at-home voting more available. It was the governor, the secretary of state, or whoever that elected official would be, or perhaps appointed official in the state. And so the same textual argument could apply there. Well, it's the legislature who sets the rules, and who is this executive to interpret it? I guess at some point you might have a state court decision deciding if the executive can do that, and that's where the federal court could kind of step in and supervise. But it does seem like the executive is also a relevant player here.
So my question is whether there is any role for the 10th Amendment in this analysis of the role of a state court with the federal courts, putting aside, again, the specific election issue that was in Moore. Is there some limitation on the authority of federal courts to inhibit the role of state courts under the 10th Amendment? Because the Supreme Court has been, in recent days, or recent years, offering a now expanded view of the 10th Amendment that it operates as a direct limitation on the actions of the federal government.
My answer would be yes and no. Yes, theoretically, but if I remember my 10th Amendment cases correctly, the Supreme Court was expanding the 10th Amendment in New York versus United States, and Prince carved out an exception for the judiciary, and it cited Testa versus Catt, where they said, well, we've always counted on the state courts to enforce federal law. Now, this is a little different, of course. This is, well, how much discretion do the states get to enforce their own law? But they just haven't really waded in much into the 10th Amendment with respect to state courts, given that they carved that out.
Yeah. And I think this is fairly cynical, but if you're talking in political terms and power, I think that for this Supreme Court, state authority perhaps is expanding vis-a-vis federal authority in some ways, but all of that is subject to judicial power. And that's what this case is ultimately about, is the authority of the U.S. Supreme Court to have the final word about these things. And that's the crazy thing. Next year is going to be a nightmare. And election law experts around the country have been saying this, that given the fact that the United States Supreme Court has stubbornly refused, even in the face of Justice Thomas calling him out on this, the court simply declined to give us any kind of standards. There's going to be a ton of litigation following the election in November 2024. There's no incentive for there not to be a bunch of litigation until the Supreme Court tells us what the standard actually is.
But do you also think they were perhaps firing a shot across the bow at this idea of state legislatures just authorizing electors on their own, which the Trump campaign tried to push after the election in 2020? That's how a lot of the media at least read this opinion coming into it.
Yeah, I mean, it was also firing a shot across the bow of the state courts.
Yeah.
Don't get too frisky, because we're watching you. That's an ancient Anglo-Saxon term of art.
Any last questions?
Thank you very much.
Thank you.
Thank you.